appeal in the matter of Renaissance Securities Limited and LLC CHLODWIG Enterprises Ors.
Yes, Mr. Lowenstein.
Lord, may it please you, I appear for the claimant appellant, together with my learned friend, Mr. Gilmore, who sits behind me, for the respondents. The second and sixth defendants are my learned friends, Mr. De Cruz, King's Counsel, and his junior, Mr. James. Mr. De Cruz has asked if you can just say something to the court before us.
Yes, yes.
And it's just to apologise to the court sincerely for keeping your lordships waiting. We were caught in an unexpectedly large queue
Yes.
at the security entrance at the side. We came in what we thought was going to be ample time, and unfortunately it was a never-ending queue. But I do apologise for the inconvenience to your
Mr. De
lordships.
Cruz, thank you. We quite understand. We hope that it won't prejudice anyone in the submissions that they need to make today, but obviously we'll keep in mind what's happened, and if we need to adjust the timetable marginally, then we would be willing to do that.
Thank you. I've agreed with my learned friend that if anyone's time needs to be cut, it'll be mine and not my learned friend's.
Let's see how we get on.
Thank you.
Thank you. Lord, some opening remarks. This is an expedited appeal. The expedition order was of Mr. Justice Lewison, Lord Justice Lewison, made on the 7th of January at an oral application by order of Lord Justice Underhill, made on the 31st of December of last year.
Yes.
The judgment below, your lordships will have seen and read,
Yes.
is at core bundle 6. Lord, I've submitted a skeleton. I rely on it in whole. I, of course, won't go through it. Most of my submissions will be responsive to points taken
Yes.
by my learned friends, and so I will try to pick up points from my own skeleton
Yes.
by incorporation.
And speaking for myself, that would be a helpful approach, because we have done a lot of reading, as you would expect.
Of course, and so that is exactly how I intend to structure things. But your lordship should, of course, indicate if they want more on anything, and I will go back. But I'll take things as read. Your lordships will have seen the procedural chronology. It's agreed at core bundle 4. The English proceedings are in green and the Russians in a sort of salmon colour in mine. I'm afraid it's already out of date. Things have moved on. Your lordships may have seen from my note that I submitted yesterday that regardless of the anti-suit injunctions issued by Ms. Justice Henshaw and others, nonetheless, the two of the defendants, including, I'm sorry to say, one of the respondents, Adorabella, have moved the Russian court for a final anti-suit injunction and obtained it at a hearing earlier this week. Now, that's relevant to context and comity, as I will come to later, but it is very serious conduct. And this was appreciated by Lord Justice Lewison, who said he appreciated how fast things were moving, and that was, for example, why he allowed the additional evidence to come in, because events had happened since the hearing below. There are 4 grounds of appeal, which your lordships have seen. They're set out in my skeleton at paragraph 7. I'm going to take grounds 1 to 3. My learned junior, in the current spirit of having juniors on their feet, is going to take ground 4. I don't want anybody to think that that diminishes the importance of that ground, but it is self-contained and subject to your lordship. It seems convenient to divide it.
We quite understand, and we encourage that attitude.
Thank you. We've all read the guidance, and my learned junior is very keen to be on his feet before your lordship, so he particularly asked to be able to do that. There is no respondent's notice. Now, this is expedited, but there was time to put one in, and you will have seen that we say, and I will be submitting, that quite a bit of what my learned friend wants to say to the court is not a reason for supporting the judgment, but other reasons why the result may have been achieved, but he hasn't asked to put forward other reasons in support of the judgment. I'm not going to make too big a point about it, but I do say that it has one very important consequence, and that is your lordship doesn't have anything in writing from me about these new points that came in from a learned friend skeleton for the first time. And I will point them out as I come to them. The sequential skeletons, mine was when I applied for permission. I asked Lord Justice Lewison if he wanted an updated skeleton. He said, no, thank you. We've got quite enough. So that was that. My skeleton's fixed in time. Learned friend's skeleton came on time, I think about a week and a half ago, 2 weeks ago, and took a bunch of new points which weren't predicated on anything. And of course, I haven't tried to reply to them in writing because there was no permission to do so, but I will have to address your lordships on those points.
Could have asked for permission.
Sorry?
You could have asked for permission.
Yes, I could have done.
If there were new points raised,
Yes,
if there were new points raised,
yes.
you would have probably been granted that permission, wouldn't you?
I would have been. The way it worked, and it's my fault for not doing it if that's the wrong thing to have done, but the way things worked was that learned friend's skeleton came in, the time for the respondent's notice then passed, there wasn't one, and so it's very unclear as to the basis on which he intends to put the new arguments.
But if you're successful,
Yes.
in your appeal,
Yes.
you're going to be asking us to do what? Exercise our discretion.
Yes, I am. Yes.
So surely everything goes into the mix.
Yes, it does. And when it goes into the mix, which is why I'm not making too much of a point about this, I'm just explaining why I'm going to have to do some things already and some not. But I took the view that at least your lordships would be assisted by the note I sent yesterday, which goes to what should happen were I to win and why.
Yes, we have been, and I'm grateful to you for that.
I think, sorry,
No, no,
I think the position is that although you have not made your submissions in response to these new points, you have put in the evidence on which you wish to rely in response to the other side's evidence. So you've got the material
I do.
and can deploy whatever submissions you want to make. Is that where we are?
That is pretty much where we are, yes. Absolutely.
Thank you.
Thank you. It's very helpful indeed, my lord. Yeah. So can I come then to what the main issue on my part of the appeal is? It's in my skeleton, paragraph 28. It's the non-contractual, vexatious and oppressive approach to the anti-suit injunction, where we submit that the court should injunct the respondents from pursuing the so-called RRE claims. That's nomenclature which has been used in the judgment, and therefore we've stuck with it. It's not strictly accurate, but we've just stuck with it. Because the case meets the Airbus test. The RRE claims clearly engage, we say, each of the considerations foreshadowed in Airbus, satisfying Lord Gough's sufficient interest in or connection with, the words that learned friend doesn't grapple with, it's sufficient interest in or connection with requirements. And we say that's because either the underlying transactions are connected with the English jurisdiction. I'll develop these submissions, but the underlying financial agreements are all covered by English law, governed by English law. They contain London-seated arbitration agreements, and critically, the Russian claims are an illegitimate attempt to outflank or evade those arbitration agreements. See Justice Henshaw's judgment, paragraphs 40 and 44, in relation to the attempts in Russia to outflank the arbitration agreement as between the claimant and the respondents themselves, authorities 2, 39 and 40. Secondly, the anti-suit would protect important policies of this forum. And those policies are in three parts. Firstly, the effectiveness of the London seated arbitral process. and the English law governed arbitration agreements. Secondly, the protection of this court's orders, which are being flouted nakedly in Russia. And thirdly, the policies that underpin the English sanctions legislation and regulations. There is another ground which we do advance and I will develop, and that is that this may be one of those, quote, extreme cases identified by Lord Gough in Airbus. Justice Lewison put his finger on it. Typically succinct judgment, if I may say so. Could I ask your lordship to look briefly at core bundle, tab 10, 151. It's the short judgment given by Lord Justice Lewison. He encapsulates many of these points in a few lines. The judgment given on the permission and expedition application.
Yes.
Core bundle 151, paragraphs 11 and 12. I'll come to the points individually in a moment. I won't read it out. The first half of 11 deals with policy, and the second half, although comity between, is the extreme case example. And then 12 is policy again. If your lordships have seen that, can I take you to the key evidence that was before the judge? I'm not going to go through all the evidence, but it is, I think, important your lordships see, if they haven't already, they will have picked it up in any event from the judgment, the pleadings in the Russian actions, because it's important to understand what is being alleged. Now, the judgment references, just so you have them, are 19 to about 21. There were two different sorts of Russian action. For Perpecia D6, there was an existing claim against my clients and what's called a joinder petition. In the Adorabella case, they have issued a freestanding claim against the RREs, but in almost exactly the same form. But it comes to the same thing. So they've tried it two different ways. Now, if I could take the Perpecia one just very briefly, that's in the supplemental bundle, tab 15 at 502, and I want to go straight to 506, please. This is the joinder motion in the Perpecia claim.
Sorry, give me the reference again.
Yes, of course, my lord. It's the supplemental bundle, tab 15. The pleading starts at 502. And the passage that I'd like to show you, lordship, starts at 506. Or perhaps I'll start at 505.
Yes.
So he said, the pleading sets out at 505 for the first 3/4 of the page, the factual background. Then towards the bottom of the page, the pleader says, under similar factual circumstances. Does your lordship see that?
Yes.
And then he sets out the details of 3 cases in which the Russian courts have adopted the approach that the pleader wishes them to adopt in this case. Those are claims against companies such as Google and Siemens. And then he deals with the propositions of Russian law that he wishes the court to decide the case upon, 3/4 of the way down 506, according to the legal positions. This is important. According to the legal positions formulated in the resolutions of the Constitutional Court of the Russian Federation, he refers to 2 court decisions. So just stopping there, this is the legal basis upon which he puts his case. The judge fell into error by not referring to this material other than in passing, but saying instead that I had said that the foundation of the Russian cases was Article 248, with which this court I know is very familiar, particularly as it's just given a judgment in relation to this material. I didn't say that. I put my case on the basis of the Constitutional Court decisions. And the Constitutional Court decisions say that compliance with the sanctions regime, and then skipping a few words, is considered unfair conduct. So to comply with the sanctions regime is unfair conduct. Meanwhile, paragraph 4 of Article 1, Civil Code, no one has the right to take advantage of his illegal or unfair behaviour. So there's the delict or the tort coming in. And then in this regard, Renaissance Capital Group cannot benefit from the fact that taking the whole group together and saying, my client, defendant 1, so it is sued, of course, which is part of it, under the pretext of anti-Russian sanctions, does not return the funds and continue to unlawfully retain them. Then the claimant entered into the contract with respondent 1. And then the next words I want are after the names in bold on the next page of Renaissance Broker and so forth. The companies included in the group had to take joint actions aimed at adapting relations with the claimant to the changed regulation in the foreign legal order and timely fulfilment of obligations to the claimant. So the Russian tort or delict is said to be that taking of unfair advantage, and specifically by not changing your behaviour to not comply with Western sanctions. You should have done something else to adapt your behaviour. And what they really mean is that Russian companies should have paid the money. And then taking into account affiliation and control.
If that had been done, then that would itself, would it not, be a breach of sanctions, presumably, if it's correct, as you say, that Mr. Goriev is the controller and so forth.
And for today's purposes, your lordships will work on the basis he is because the judge found it.
Yes, quite. I'm just noting that there is ultimately a dispute about that, but this is the basis on which we're presently working.
Precisely, which is, I'm trying to put my finger on what's really at the heart of this case right at the beginning. So if there had been an adaptation of an adaptation of relations, to use the words of the pleading, then we have said that that would have been a breach of sanctions, as your lordship exactly says. And so my clients are put into the invidious position of being a defendant in Russia, but also subject to these further claims against them. They're a defendant on the contractual basis already, but there are these new claims in which they're a defendant on the tort basis for exactly the same claims, and that RREs are defendants as well, to make my clients jointly and severally liable. Now let me just show you the rest of this section. There's the taking into account where I stopped, taking into account and control of these persons, and then it was not difficult for them to transfer the performance of obligations to the plaintiff from defendant 1 to Russian legal entities. So that's what they say they should have done. Should have given the obligations to another company, which are not subject to sanctions, regulations of Western countries. Now, can I ask your lordship just to note this? It goes to another point for later. Learned friend says I'm not very clear about what sort of sanctions I'm talking about, but their own pleading just calls it the sanctions of capital W Western countries. And so the Russians understand very much that there are a group of sanctions which impact, and we say this court has direct interest in protecting my client from being put into breach of that by the forcing that's going on against them. D1's refusal.
Why do we have an interest in US or EU sanctions?
Well, the English sanctions are the critical ones.
Well, quite. I understand why we might be
Yes.
interested in those.
Yes.
My question was, why are we interested in US or EU?
Well, you're not interested directly in enforcing those, but if my client, which has a contractual right to arbitrate in England, where it will raise the impact of all the sanctions which prevent it from paying over the money. That is context, which is important for your lordship to understand. It's part of the protection of the arbitration which will decide those issues. And all of the sanctions will be in play in the arbitration. This court doesn't have a direct policy interest in protecting the sanctions of other states. I accept that. But it does have a policy interest, as I've said, in protecting the arbitration and the arbitral process where these matters will be in play. And one can see what it's being protected against, because this is the countermeasure in Russia.
So you say, do you, that if there ever is an arbitration, it would be for the arbitrators to decide whether, under an English law contract, US or EU sanctions gave your clients a defence?
Yes. It's one of the defences that will be before the arbitrators. And this is, as your lordships will know, because they've seen other cases that are similar, but this is now a very regular problem that's happening, cropping up in relation to all sorts of financial instrument contracts. I'm putting it very broadly. Can I just show you the last part of this? Because it's the, perhaps even the critical part, the next paragraph, the legal basis for the joint and several liability of defendant one, that's my client, the legal basis for my client's joint and several liability, and the others, which are part of the Renaissance Capital Group, for losses caused to the claimant. And then it gives the well-known Articles 322 and Article 1080 of the Civil Code of the Russian Federation, according to which the persons who jointly cause the damage are jointly and severally liable to the victim. So this is the creation of a tortious claim through the imposition of joint and several liability against my client and the others in circumstances where my client has a right to arbitrate under the contract. So this is a way of working around the arbitration agreement and seeking to achieve a result where joint and several liability is created, that the judgments will be entered in Russia. In fact, since Lord Justice Lewison had this case, and this is one of the most striking things about the broader context. Lord Justice Lewison heard this, the application on the 7th of January. He was told that there was an upcoming hearing in Russia for final judgment on the Popecchia matter on the 9th. I asked him to make an interim anti-suit injunction to protect my client pending the coming on of this appeal, which required, in very broad terms, that hearing not to go ahead, not against the court, of course, but against Popecchia. Completely ignored. They went ahead, and judgment has been entered against my client on the Popecchia matter. 2 days later. Flagrant breach of the injunctive right, their injunctive obligations, couldn't have been clearer, have entered judgment. And what will then happen if I'm unsuccessful is that there is an appeal process. The appeal process in Russia, there's an automatic right of appeal to the Court of Appeal. That's likely to take a matter of weeks or months. Judgment is not able to be enforced until that happens, which is why I say in my note at the moment, an anti-suit injunction will suffice because there is no enforceable judgment at the moment. And anti-enforcement injunctions are becoming rather a hot potato following the Google decision of Miss Justice Henshaw, handed down just a week or two ago. A long judgment looking at the entire horizon of the anti-enforcement scene. And so what will happen is that will be an appeal and then another appeal likely to the Supreme Court of Russia, again under an automatic right that permission doesn't need to follow, And then if there are no antecedent or injunctions from this court, and those appeals are, if the defendants carry on not withdrawing their claims, and in Russia you can withdraw a judgment. Unlike us, where once judgment is entered, there needs to be an appeal which isn't resisted. In Russia, so I understand, I've got no evidence about this, it only happened in the last few days, but in Russia, so I understand, a respondent to an appeal can say, I don't want my judgment anymore. But if the matter goes ahead, then there will be enforcement against the Russian entities, and then they, because of the joint and several liability, are likely to bring what's called a recourse or a contribution claim against my client. And that completely reverses the position, because if enforcement happens against the Russian entities, then the English defendants will be in the money, and there will have to be a fight between the Renaissance companies as to where the money comes, where the loss falls, and whether or not sanctions prevent the payment over of money to restore the position. So that's the entirety of the picture.
That is the basis of your case.
Yes.
That these proceedings are vexatious, oppressive of you.
Yes.
Is that there would be recourse
Yes.
against you
Yes.
by the Renaissance
Yes.
Russian entities.
Yes.
And how does that recourse arise?
So that recourse arises because the Renaissance Russian entities, there's evidence about this, but the Renaissance Russian entities will say to my client, we have had to satisfy this claim for which we were not contractually liable. We are now out of pocket, and therefore we claim against you, Renaissance, which is a Cypriot company, to make us whole because we've had to pay out in Russia. So you pay us, and my clients will then be left in an invidious position, because if my clients, which are holding assets which they say are sanctioned, will be in a position where they will have to either pay that money over to the Renaissance Russian entities in circumstances where at the moment they're not permitted to pay to the defendants. Will they be able to pay to the RREs? We don't know, but it looks as though that will be treated as being sanctioned money, because this court will take the view, and there's similar authorities, including in the Fortanova litigation and so forth, where the assets that are held and which are sanctioned can't be paid over because they're given another name, or because there is some other route by which they are being claimed. And so what we say is that this is a simple outflanking manoeuvre, and I use that word advisedly, this is the word that Mr. Justice Henshaw used, an outflanking manoeuvre to stop the protections that my client would have in the LCIA by being able to run its sanctions defences, that other companies will claim against me, and then those other companies, and I have a legitimate interest if this is the point that can be taken, it's not in the respondent's notice, but I have a legitimate interest then in what happens in the RRE actions, because even if I can't be enforced against directly, I will end up being enforced against because of subsequent litigant action by the RREs likely taken against me in Russia. Does that answer your Lordship's question?
Well, what is the nature of the right of recourse?
It's a Russian law right of recourse, first of all, and I'll put my finger on it in a moment. But the right of recourse is a claim. We would call it. Well, I don't want to make it up, but the right of recourse is a claim by those RREs which are jointly and severally liable, and therefore they can claim against their joint tortfeasor, as will have been established in Russia.
But forgive me, but when you applied for the relief, I thought the point was that these were your affiliates.
When we applied for our relief, two of them were my affiliates, and are now no longer my affiliates. One of them is. Learned Friend says, well, it's very unlikely that anybody's going, that the affiliates will sue one another. But my client's position is that, first of all, two of them have been sold out.
During the course of all this?
Yes, well, after the hearing before His Honour Judge Pelling.
In that case, that sale agreement must have dealt with this potential situation, mustn't it?
I don't know, because and Learned Friend has asked for that sale agreement, and I've told him, when I say I have, my solicitors have told him that I'm not party to that sale agreement, because that sale agreement is between those who owned the companies and the parties to whom the sale has been made, and therefore I'm unable to furnish it.
Only because your beneficial owner is not providing it to you.
That may be, I don't know.
Well, a natural inference would be that that sale agreement will have dealt with this issue in some way.
Yes.
So I'm not sure how you can say to us that we should infer that there is a right of recourse unless we have some understanding of what those agreements provided.
Yes.
And it seems to me now you've changed the basis of your application. Previously it was they're getting around the sanctions by going after our affiliates, which is a way of getting at us.
One of them still is an affiliate.
That now you're saying it's no longer on that basis. It's because they have a right of recourse against us, but that right of recourse depends upon what's in the agreement, and you can't tell us that there is a right of recourse.
Yes and no. Your Lordship is right. There may be a contract saying there's a warranty or there is a right of collection or whatever, but whether or not that's...
There's no warranty or no right of collection.
Or there's no warranty or no right of collection, but whether or not that could in any event be complied with is from assets that are held subject to sanctions is a different question, and it's a totally different question. It doesn't often matter what the contracts say if the bite of the sanctions is there, and the dealings of the parties inter se are, in my submission, not relevant and expressly not relevant to the effect of allowing the actions against the related entities to proceed and to have those then be required to pay. They then, and the evidence is, are likely to sue me for that for that money, those assets, and whether or not I can pay it is a question of sanction. So the effect of what will have happened, this is an effect that the court should have regard to, is that had this dispute, in which I am a defendant, it mustn't be overlooked that I am a defendant in the Russian proceedings, not only on a contractual basis, but also on the tort basis. If the arbitration agreements had not been broken, I could not have been made a defendant in the Russian proceedings at all. I couldn't have been because the arbitration agreements, as your lordships will have seen, I can take you to them, provide not only for contractual but non-contractual disputes to be referred to arbitration. So that the dispute that is being brought against me in Russia must have been referred to arbitration in London, where the effect of sanctions would have been considered. If that had happened properly and that obligation had not been broken, which is highly relevant to this court's approach to this application in my submission, if that had not happened, then there would have been a claim brought, not in Russia, but in arbitration in London, and the RREs could have been brought in as additional defendants under the provisions of the LCIA rules.
And they still could.
And they still could, but it requires a learned friend's client to start that arbitration.
Well, actually, it doesn't.
Well, I could start a negative arbitration. Sorry?
Good.
I
You've done
could.
it months ago if you wanted to.
I could have done, yes. But we have been in the trenches fighting these regular assaults from Russia, and being saying we could have asked for a negative declaration. It's not the point, with respect. The point is that the defendants chose to bring their actions in Russia in breach of the arbitration agreements, and everything flows from that. All these points, the points that Justice Phillips is putting to me, and the other points that learned friend argues against me, could not and would not have arisen in this way had those disputes been brought before the arbitrators and not in the Russian courts. I would not be exposed to joint and several liability in Russia. There wouldn't be claims against me in this way. And if there had been separate claims in Russia against the RREs, that wouldn't be, for the purposes of today, my business.
Have I correctly understood that to the extent that you are a defendant in the Russian proceedings, you already have the benefit, such as it is, of an English anti-suit injunction? It may not be helping you very much if the other side are ignoring it, but
Yes.
you have got it,
Yes.
and we're not concerned with that today. What we are concerned with is simply whether there should be an injunction to restrain proceedings against the RREs.
Precisely. Just as in so many of the cases,
I wanted to clarify that because you emphasise the fact that you are a defendant in
yes,
Russia, but
I am.
so far
With
as you
Justice
are,
Henshaw's
you've got
order.
such protection as the English court can give you,
Yes. it's not-
subject to any further steps you may take arising out of that.
Yeah, precisely. But indeed, I've got a negative anti-suit requiring no further steps, but I've also got a mandatory anti-suit. It was an unusual order, but it was granted at the hearing, requiring those proceedings to be withdrawn.
That's been ignored.
Totally ignored. And so this is all material that goes into the comity question and the broader context question and the discretionary question, because if the court is faced with a series of defendants who have ignored their obligations to sue me in arbitration but have gone to Russia, and then try and take all the illegitimate advantages from that, then we're into quite well-trodden territory, where we've got cases before the court, but they're well known to the judges here, not only judicially but also as counsel, which express very clearly that the, quote, non-party claims will not be allowed to be used, to frustrate the object or the effect of the arbitration agreements and the contract. And that's just what's happening in this case. And there are many examples, including the recent decision of the Supreme Court in Singapore, the Asiana case, Lord Justice Mayall's case when as counsel, the Shell case, and so forth, where you have non-parties suing in another jurisdiction, trying to leverage then their own breaches into a right of action abroad. And so, coming back to Lord Justice Phillips' question, because I don't want to let that lie, it is important, but with respect, it's not the point. The point is that it shouldn't have happened at all.
Well, forgive me. That's take for granted that it shouldn't have happened.
No.
let's take for granted that if they had sued, so if they brought an arbitration claim and brought these allegedly joint
Yes.
tort fees in, then none of this would happen. Well, of course not.
No.
But we have to look at where we are.
We do.
And there are two things that you said that I'd just like to ask you about.
My lord.
The first is, you said that if an arbitration had been started in London, if separate proceedings had started in Russia against the RREs, that would have been none of your business.
Yes.
Why do you say that?
Well, it
Because there still
depends.
have been a right of recourse, wouldn't there?
It depends what there would have been a right of recourse, but it depends on the basis on which that was started. And so perhaps I've overspoken. What I had intended to say, and perhaps I've said it very badly, is the pleadings in Russia as currently framed make a joint and several liability claim against me and the RREs. If there were claims in Russia as group claims where I was not included, then the exact framing, because we're always told to look at the substance, with Justice Bryan's case, so Quingdale, which does no more than state a very well-known principle. You have to look at the reality, the substance of what's happening, not the form. If the form of what was happening abroad was again an attempt to try to outflank my arbitration agreements and frustrate them, then I would have an interest. And I.
So that answers the second question I
Yes.
asked you is this.
Yes.
You put it on the basis that this is an attempt to outflank
Yes.
the arbitration. But if they are ignoring the anti-suit injunction
Yes.
in relation to proceedings against you,
Hmm.
and proceedings against you are continuing in Russia,
Yes.
what difference does it make if they're also suing the RREs?
Well, it's a mixed bag. And first of all, this court cannot say, well, my orders are being flouted, so my orders are pointless. Secondly, and more
No, but
importantly,
forgive me, but we're not looking at whether now our orders are pointless. The order vis-a-vis
yes,
you
yes,
is in force, and the defendants on the face of it are in breach of those orders.
some of them
What
are.
we're looking at now
Yes.
is whether there's a justification
Yes,
for granting an anti-suit
yes,
against other parties who, at least now it appears in relation to two of them, are not associated with you.
yes.
On the basis you say that they might have a right of recourse against you, but you're being sued in Russia anyway, primarily. So the right of recourse doesn't arise in that circumstance, does it?
Well,
because you'll be the one who's primarily liable.
Well, but first of all, the location of assets is important, and the assets that we are holding are sanctioned and therefore can't be paid over. Secondly, Your Lordship goes a little too far because he doesn't know perhaps enough about the background to say that the anti-suits are not effective. Some of there are 6 actions in Russia.
Some of them have been discontinued.
Some of them have been discontinued, and Miss Justice Foxton particularly observed it when I appeared before him in the summer for clarificatory orders, because there was a lot of lip service being given, so the orders had to be spelled out. He was encouraged by the fact that some of these orders are being effective. So we can only do our best, and the best is to put orders in place that one hopes the Russian judges will respect when shown them properly. Now, sometimes they are shown the orders and they are just put in front of them with no proper submissions. Sometimes they are put in front of them and proper submissions are made about them. It's always the same advocate on the other side, Mr. Trekhanov. And it depends, I guess, on what his instructions are on any particular day. But the Russian judges who are handling these cases, and it's a relatively small number of them, both in Moscow and Kaliningrad, Judge Sorokin is the main judge who's been handling these cases in Moscow, was surprised, there's evidence about this, was surprised to be told in respect to one of the anti-suits when he was shown it, and he was told it's just a piece of paper. He raised a judicial eyebrow at that. There is respect that is given to some extent. The judge in Kaliningrad seems to have taken a harder line both earlier this week and in and I forget where the January final hearing was. I think it was in Moscow. So the answer again is that the anti-suits are of serious effect, and those orders of Miss Justice Henshaw ought to have been complied with, and in part have been complied with. And part of our hope and expectation, now that we're in the Court of Appeal, is that if there were a more than an interim order from the Court of Appeal requiring not only the non-prosecution of the Russian proceedings, but also the withdrawal of them, which the judges below have been content to make as orders, then that will be given respect. And if not, then we could all go home.
Do the respondents have assets or personnel within the jurisdiction?
This jurisdiction. Some of them are based in Cyprus, and so they are easier. So, for example, Perpekia is a Cypriot company. It's one of the judges, the errors of the learned judge. He said thought they were both Russians, and they're not, and that's now accepted in parentheses at one stage, and friend skeleton. But there are, I don't know beyond that whether there are, and your lordship is thinking about possible committal. And whether or not there would be teeth. I'm thinking ahead as to why your lordship might have asked the question. But of course, it's something actively on our radar. But before starting the satellite litigation of committal, we need to deal quite urgently and quite regularly with what's in front of us.
Right, now, how are we doing in the structure of your submissions?
Not well, but I have said quite a lot of what I want to say. So shall I press on and say some of the things that I wanted to? Let me just regroup just for a moment, if I may. Thank you. So your lordships know, I'm not going to go there, that we set out the wording of the anti-suits at paragraph 12 of my skeleton. We set out some principles of law at 22. I'm going to pick those up as I go through, but I want to come straight to ground one,
Yes.
the threshold forum issue, and ground 1.1 that the judge was wrong to hold that there was. So the starting point, of course, is the judgment where the vexatious and oppressive injunction is dealt with at page, it's almost entirely disposed of, at page 70 of the bundle, paragraphs 21 to 44. Your lordships will have 45. Your lordships will have scrutinised this. With respect, it's a difficult decision, and I don't wish to be disrespectful in any way to the judge. He was dealing, as our learned friend says, with an expedited case, an expedited hearing, and he gave an extempore judgment with notes 2 days after he'd heard the matter. So for that we were grateful. But it's quite difficult to decide what he was actually deciding, because some of the things one imagines he was deciding are actually have to be implied out of what he was saying. So the structure of it we dealt with at paragraph 21 of our skeleton. Again, I'm not going to go through it, but the key conclusions that he drew, paragraph 41, he said 2 questions generally arise, and then he set them out. Are the courts clearly in the most appropriate forum for the trial?
Yeah.
Is it necessary in the interest of justice to grant the injunction, taking into account considerations of comity? And then he referred to Clear Lake. 42, he then referred to the defendant's submissions on the forum issue. Now, your lordships will have those well and clearly in mind. I'm not going to read them out, but it's very important to note that he impliedly agrees with the defendants, because he doesn't ever actually say he does. Now, again, it's just the structure of a judgment produced under pressure of time, and of course one understands the pressure of judges that way. But the principles that the defendants argued for, which are those to set out and which he calls the forum issue and became the substance of the judgment, are oddly not supported by the defendants in their skeleton. They don't deal with it. And they've gone on to other grounds.
Yes, so certainly, Mr. Lowenstein, the way I understood the judge's reasoning, towards the bottom of page 70 of the bundle,
Yes.
in paragraph 44,
Yes.
the last 4 or 5 lines, this appears to be crucial to his reasoning. On the arguments advanced before me, there is no answer to the point that there is no alternative jurisdiction available.
Yes.
So, correct me if I'm wrong, but I had understood him
Yes.
to be directing himself, as a matter of law,
Yes.
that is a threshold requirement.
I was literally about to say that. So
Okay,
it's an
okay.
implied direction, but what he does is sets out the defendant's arguments and then says there is no alternative jurisdiction. And so expressly he says that there's a threshold forum issue. Impliedly he says he directs himself that it's necessary to identify the alternative jurisdiction. And then expressly he says because the only alternative jurisdiction that we had identified was the LCIA, and he had found that that was not available. Therefore, he didn't need to deal with anything else, and he says so expressly.
So your ground 1 is that as a matter of law, there is no threshold requirement. But even if you're wrong about that, ground 2, the LCIA arbitration possibility does provide an alternative jurisdiction.
Spot on. Yes, exactly right.
You don't need ground 2. Is that right? If you win on ground 1.
Correct, yes. And I was going to actually deal with the structure of how we win, as it were, in just a moment. So it's absolutely critical to understand that this short passage is wrong on several levels, which I could or won't develop as your lordships require. There is no requirement in law for the English court to be the natural forum, or for there to be any alternative forum at all, because we see many cases where there are single forum anti-suit injunctions. So long as what I'm going to call the Airbus tests are met, and those are broadly sufficient interest or connection or extreme case. That's the structure of the law that we say the judge should have adopted, but didn't. It was also wrong just on the question of whether or not he took into account my submissions. Your lordship will have seen from my skeleton and from the judgment that he said I made no submissions about this because it wasn't in my skeleton. You'll have got the point why it wasn't in my skeleton. It was expedited. It came in, Learned Fred skeleton came in a couple of days before the hearing, after mine. It was responsive. And so the first time I dealt with it was on my feet. And I did, I can show you lordships by reference, I've given the transcript references.
We've seen
You've seen it, so I don't need to go through. So just to be clear, we do say that this is an alternative forum case, but if only a single forum is available, then nonetheless an anti-suit can be granted. Learned Friend skeleton doesn't support this critical reasoning of the judgment at all. They don't even attempt to support the proposition that there's a threshold requirement of natural forum, even though they argued for it below. Their arguments are that the judgment should be upheld for different reasons, and that is that there's a sufficient interest point.
Yes.
Now, what they've done, and therefore I can't criticise it, is I set out the law with sufficient interest in my skeleton, and then they've loaded onto that. And so I can deal with it, and I will now.
Yes.
So why does the English court have a sufficient interest? Well, I've given many of these submissions already, but it has a sufficient interest or connection with those Russian proceedings because they concern English law governed contracts. I'm a contractual defendant as well as a tort defendant. Learned Friend's complete answer to the lack of connection with England is the contracts are only background. Maybe he's paraphrasing very slightly, but he says the contracts are only background. And
That answer only what?
background,
Background.
yes,
Thank you.
they're not. It's the beginning and the end. It's the same claims for the same losses made against other people, which couldn't have been brought unless there was a contractual claim for them for the assets. And the way it's put in the Russian pleadings, which is why I went there first, is effectively you haven't paid under the contracts. That's unfair, and so there is a tort liability.
Well, the Supreme Court said in Unicredit that English law was a sufficient interest or connection, although that was in the context of a breach of contract case.
Yes, and that's why I haven't run Unicredit. I brought it. Of course, we read it, and it's very helpful. And of course, there is the more recent decision, this court, we're one of the Constitution with Judge. But I don't need to go that far. But Lord Leggett talks in Unicredit in the Supreme Court about the importance of English law and also the overriding importance of giving effect to the policy of the English court to protect arbitration. I think it's paragraph 76 or 77 from memory. So the English court I was dealing with sufficient interest or connection. English law governed contracts with a broad reference to, and these are the words of the choice of law clauses, broad reference to, quotes, non-contractual obligations arising in connection with. And that's Core Bundle 8, page 128. They contain very wide LCIA London seated arbitration agreements, including the well-known phrase, not only the contracts, but claims in relation to the contract. Core Bundle 8, 128 as well. And because of the three, the trident of policy issues, which I referred to before. And also, if necessary, we do say that this is a so-called extreme case. Now, moving immediately now to deal and to catch up with time on Learned Friend's submissions and our answers to them, which I hope will provide some assistance. So there is the legal principles, Airbus. There's quite a lot of common ground here. There are some missing points for Learned Friend's analysis, which I therefore need to develop. And this is where I'm now going to answer Lord Justice Singh's queries as to what are the results on a determination on each part of the case. So there are three key propositions on what I hope I'll be forgiven for calling jurisdictional nexus arising out of Airbus, which I want to make good now. So I'm going to set them out and then deal with them by reference to the case. The first key proposition on the jurisdictional nexus, I'm labouring this slightly because I know the transcript may be looked at, is that there is no threshold forum requirement that the English court be the natural forum for the dispute. So instead, the only requirement imposed by comity is for the English court to have sufficient interest or connection in granting the anti-suit, which may be satisfied in a number of ways, not just through forum issues. And to answer Lord Justice Singh's question, if correct, this point disposes of ground 1.1 of the appeal and is a win. The second key proposition on jurisdictional nexus, that the English court will have sufficient interest or connection in granting an anti-suit where either the transaction is English in character, so for example, choice of law, and or where the English court grants the anti-suit to protect important policies of the jurisdiction, including the enforcement and protection of London-seated arbitration agreements and procedures. If correct, that point disposes of my learned friend's new grounds of sufficient interest. The third key proposition in this area is that the English court may have such a sufficient interest even where arbitration has not yet started. Throughout many places in his skeleton, learned friend says, well, there is no London arbitration. In my words, so what are you talking about? And the answer is that the authorities say expressly, and the learned Mr. Raphael comments as well, that no, there is no need to have.
That's well-travelled ground.
It is very well-travelled ground, and it's surprising that this point is being taken at this stage. But I'll give you the references when I come to it, so you've got it.
Can I just, Mr. Lowenstein, forgive me for returning to your second
Yes,
key
Lord.
proposition. I can understand that proposition so far as it concerns the original ASI that was granted to protect
Me.
your client
Yes.
as such. But as my lords have observed earlier today, this appeal arises from the attempt to vary and extend that,
Yeah.
so far as other proceedings in Russia are concerned. Now, I'm not sure, speaking for myself, I entirely follow your key proposition too, that you dispose of it simply by pointing to the fact that there are important policies in this jurisdiction to be protected. I mean, they were there and being protected by the original form of the ASI.
Yep.
So don't you have to show that there is a sufficient interest or connection in relation to the actions against the RREs in Russia? And I don't want you to traverse old ground.
No.
I think you say there is an answer to that, which you gave about half an hour ago, but is that where all of that analysis comes in?
It's partly, yes. So on the second ground, the first of all, is the transaction English in character, and that one has to look at the foreign pleading to ask the basis on which the foreign pleading is, the foreign action is being put. And we say that the RRE claims are only being brought because they point to the failure of my client to, in their language or approximate language, to honour its contractual obligations, and therefore they bring a tort claim for the same loss. So the claims would not be happening were there not an underlying English law contract, and it's just doesn't help anybody to say, well, the contracts are not relevant to the tort claims. They wouldn't exist if there weren't contract claims.
Forgive me for this going back over old ground, but if the RREs were not connected to you, and if there was no right of recourse, then there wouldn't be a sufficient connection.
Well, I've now been reminded of where the material is on the right of recourse. And what we did was, on as long ago as the 4th of October, well in advance of the hearing before the judge, we wrote to the English defendants to set out our case on right of recourse. The reference is Supplemental Bundle 14434. So this is how we understand the law to work. Put it up myself, 434. And what we did was we sent a letter attaching a letter of the Russian lawyers, setting out a short description of the joint liability for torts, the possibility of one tortfeasor to raise recourse claims against the others, and the possibility to raise a recourse claim against a harm doer if the harm was compensated by another person, i.e. my client, somebody else pays, and then there could be a claim there. And the Russian letter, which was sent to Enyo, I believe, on the 4th, and that would have been by the letter immediately beforehand, which starts at 429. I believe that's correct. And we asked them to say if they disagreed. And they didn't respond. Oh, this is in evidence, this letter, that's why it's in the file. So the short point is that the right of recourse is a statutory right, which as a matter of Russian law cannot be contracted out of. And that's the answer to Lord Justice Phillips' question, which I had forgotten the answer to, which is why it doesn't matter what the contracts might say.
Where do we see that?
That's on instructions, I'm afraid.
So what is on instructions that it cannot be contracted out?
Yes.
I don't understand that.
Sorry.
You've shown us a letter from Russian law.
I have, which sets out how the law works. I've also been given instructions that if it's relevant, we can ask your lordships to receive evidence about it, that the right of recourse, and I'm reading, is a statutory right, which as a matter of Russian law cannot be contracted out of.
Does any of that turn on whether an entity in Russia is an affiliate of your clients or not?
No, because if they are sued as joint tortfeasors, it's a point that the evidence makes. If they, what we, as your lordships will have seen in the most recent evidence, although we use the word affiliates, it's because they were. And what we have done is explained that the exact corporate relationship between the different entities doesn't matter. What matters is the basis on which they're being sued and the risks that then follow from that.
If you look at the top of 436, it says that the tortfeasor who has compensated for the damage has a right to demand a share in an amount corresponding to the degree of guilt of this tortfeasor.
Yes.
If it's impossible to determine the degree of guilt, the shares are recognised as equal.
Yes.
If they're all, if under Russian law they're all equally liable because everybody in the group is tarred with the same brush, then the liability of you would only be to pay a proportionate share, i.e. the proportion that you are to the members of the group. So if there are six of them, for example, who are liable, you'd only be liable to
But I follow that.
pay a part of it.
Yes. It depends how it's seen in due course, who is responsible and who isn't. But the minimum is going to be a share. It could be more.
The difficulty may be, Mr. Lowenstein, that as my lords have, I think, observed earlier today, the original basis of the application that was made to the judge below was, as I understand it, on the basis that these other entities were affiliates of your clients. And if that factual foundation has at least to a material extent changed, then don't we need to know chapter and verse about what's been going on?
One of them still is.
And,
so
and on your legal submission, is that sufficient
Yes.
to maintain your application?
yes, let us say that judgment is entered against all four. And that enforcement in Russia happens against the one that is still an affiliate. There's no change.
That's credit, is it?
I think so, yes.
Mr. De Cruz is going to say, I suspect, may be wrong, but I suspect it's going to say that there is a lack of candour on your part in explaining what has gone on.
Yeah.
And if we were to accept that submission, that would put you in a difficult position seeking a discretionary remedy from this court on the assumption that you make good your grounds of appeal.
Yeah, well, the sale contracts, neither my client nor the RREs are party to.
Well, that's your witness's fifth statement, isn't it?
Say again, sir.
That's what your witness's fifth
Yes,
statement
it does.
explains.
Yes.
Yeah.
Yes. But as I say, there's material before the court, which I should have put my finger on earlier, which shows clearly that there is a right of recourse, there is a right of contribution between the tortfeasors. There is evidence that one of the respondents is still within the group, the RREs is still connected, and so nothing has changed there. So even if your lordship say, well, the others have gone, this one is still there, and that's a serious matter. And the others, it doesn't matter whether they're in or out of the group, if they've gone out and are owned by somebody else, but are still being sued as joint tortfeasors, then the issue will be whether or not my clients are exposed to a risk. And the risk, even if on a complete hypothetical, even if the risk were covered by the sale contract, as I've said earlier, I don't make this submission any better by repeating it, but I'm going to in any event. Even if the sale contract said you're immune from that risk, or if it didn't, my clients will still be in a position where, if they are required to pay over the assets on a contribution claim, then those assets will be likely regarded as sanctioned assets.
That's the position they're in anyway, vis-a-vis respondents.
Yes, but
It doesn't change the position.
I'm sorry, I didn't hear the last bit.
It doesn't change the position, does it? At the moment, as I understand it, you are liable. You would be liable to the respondents, but you are not able to pay because of sanctions.
Yes. And what I've also
And that would just transfer the position from the respondents to the RREs, wouldn't it?
it would transfer the position, but the claims that will come in against me will be in Russia without the benefit of an arbitration.
But they are at the moment.
Well, they are, but I've got anti-suit injunctions to stop that. If your lordships grant me a further anti-suit injunction to stop the actions involving the RREs, then the actions, if the premise works, the premise that the anti-suit injunctions are successful work, then the matter will be driven to the LCIA, because the English defendants will properly start their LCIA arbitrations. There's no forcing in this.
If they can proceed against you in Russia, they don't need to. They don't need the RREs.
I'm sorry, they can't proceed against me.
I don't understand how claiming against the RREs changes things if you are being proceeded against in Russia.
Well, I'm going to take this back to the first step to try and answer that question exactly. There should not be proceedings against me in Russia of any nature, contractual or non-contractual. Those proceedings should have been withdrawn. This court should not tolerate an argument which says, oh, well, because we're proceeding against you in breach of the English injunctions and in breach of the arbitration agreements, because we're doing that in Russia, we can load in the RREs and therefore nothing matters. you have to go back to the beginning. Justice Henshaw's order should have been complied with. There should be no joint and several liability proceeding against me in Russia.
No, that is all understood by this court, but anyone who finds themselves in that situation where an order of this court or the courts of this country is not being complied with has potentially open to them steps that can be taken.
Yes.
And that would remain true whether or not this particular facet of the litigation had ever occurred.
Yes.
And whether or not this appeal were taking place. So all of that is understood, but that hasn't changed. But what as my lords have observed earlier, what we're critically focusing on is whether you're entitled to the additional
Of course.
ASI.
That's why I'm here.
And you say that the judge was wrong to refuse that order, and we understand your grounds of appeal. You developed certainly the first of those so far. But I think what my lords are really asking about is even assume, and we haven't decided this case at all, obviously, but even assume that you succeed on at least material parts of your appeal. In practical terms, where is it all going to end up? And I think that's what, at the moment at least, they have been interested in.
Well,
and it may be that we haven't been given chapter and verse on what the up-to-date position is.
Yes. But where it's all going to end up, which is critical nub issue, is that if your lordships agree with my submissions and are minded to grant an injunction, that should terminate the RRE proceedings, i.e. the claims brought by Perpecia and Adorabella against those other group companies in Russia. Because that's what I'm asking for. I'm asking for those proceedings to be injuncted because of the effect on me. Just as all the other cases that look at non-parties and have granted injunctions stop the foreign litigation by injunction because it's vexatious and oppressive to this jurisdiction for one of the several reasons that one can envisage. And I'm very conscious of time as well.
No, the court inevitably has questions for you, so we're not complaining at all, Mr. Lowenstein. But can I just ask you how, in the overall structure of your submissions, and I know your junior has to speak as well.
Yes.
How are you getting on?
Well, I'm answering questions as we go, so it's clearing away issues that I was going to deal with later.
It is.
But I haven't shown your lordship any of the authorities. Maybe I'll have to do that by reference rather
Yes,
than.
I think that's probably right. We have read
Sure.
the
So I can
authorities.
just refer to them.
Yes.
And I can pick up the most important points.
That would be
and
helpful.
I've come prepared to do that.
Thank you.
But I do want to get to the where does it all end up. If the injunction is granted, then the assumed position will be that those actions, Adorabella against me and RREs, Perpecia against me and RREs, stop. So when you say they'll just carry on in Russia, no, they won't. It'll be over, game over.
I see.
And so the only place they will be able to sue, we say there is an alternative forum. The learned friends are correct in that the only place in the world they can sue is Russia, then it's got to be one of the extreme cases.
Yes. Just in terms of timing,
Yes.
I'm going to make this direction.
Yes, my lord.
Because we started a little bit late, for reasons we quite understand, I'm going to expect your side, excuse me, to finish by 1 o'clock.
1 o'clock.
And that includes time for your junior to develop ground 4. All right.
I understand.
And I hope, Mr. De Cruz, that won't prejudice you unduly this afternoon.
I don't expect it will.
Very good. Thank you.
I'm going to take things sort of succinctly now, rather
Of
than
course.
in a developed way, but I'll be stopped when the questions come. And I hope to be asked the questions. It's important. So I've given the 3 propositions on jurisdictional nexus. I'm just going to give the references in Airbus now. I don't have time to read them. So
That's fine.
Airbus, you'll find in Authority 680, starting at page 95, and the key passages that I rely on are the distinction between single and alternative forum cases, starting at 134B to F, the judgment. Alternative forum cases are developed 134F, and the important part of that is that Lord Gough said that in an alternative forum case, an anti-suit injunction will normally, important, only be applied for in an English court where England is the natural forum, and if so, there will be no infringement of comity. So normally, and then he refers after citation of Ares Spatial, 135C to the general rule, but a 140B to C, he says again, the principle is a general rule not to be interpreted too rigidly. And he was assisted by the American judgments. And I emphasize, of course, normally and general rule. Now, in the single forum cases, that's 138C, Lord Gough, you'll recall, considered the Laker Airways litigation. That was a single forum case because the antitrust proceedings could only be brought in the United States. And importantly, he explained the wider principle that may be taken from the single forum cases, and I quote, these single forum cases demonstrate that any limiting principle requiring respect for comity cannot simply be expressed by reference to whether the English court may be the natural forum for the dispute. Such a principle would have to be stated on a wider basis. Now, the application to this case, learned judge was, with respect, and was simply wrong to conclude it against that background that the English court was required to be satisfied that the forum issue, as the judge called it, not least because Lord Gough made the point that the respect for comity can be satisfied in other ways.
Can I just mention that I said some very similar things in the SAS and World Programme case, not nearly as eloquently as Lord Gough, but they are, if anybody wants to look at them, I don't suggest that we should do so now.
Your Lordship did.
At paragraph 108 and following in tab 28.
The two-way street.
I think that was one of the things I said. Yes.
It was. It's a case with which I was very familiar because, in fact, that was the only hearing I didn't do in that case. It was in the first instance, but was indisposed at that time. I followed very closely what your Lordship said, and comity is dealt with at length, so I don't need to develop the principles at all, and it remains the last word on comity subject to the Supreme Court. As your Lordship knows, SAS settled before it was heard in the Supreme Court. Or may know, it was going to the Supreme Court and settled.
That's a good sign, is it?
Well, so it is the last word for the time being.
Yes.
But it had been through a trial in the commercial court on other issues.
It was the end of a long course. Anyway, we don't need to go there.
We don't
Just
need
in
to go
case you
into it.
weren't aware of it, obviously you are. I just wanted to.
Thank you. It's very helpful. I was going to come to it. I don't need to now. But the satisfaction of the comity principle, Lord Gough 138G, sufficient interest in or connection with the matter in question. In an alternative forum case, the natural forum is the most straightforward way of dealing with that. But the single forum case, I need to deal with the hard case against me in case my learned friend is correct. And indeed, learned friend says that this is a single forum case. England being the natural forum can have no application because it's illogical to ask the question. It just doesn't arise. And so at 139G, drawing on Justice Wilkie and Laker, Lord Gough said, In such a, by which he meant single forum case, it may, however, be possible to establish a sufficient connection with the English forum. In particular, this may, and then the well-known passage, involve consideration of the extent to which the relevant transactions are connected with the English jurisdiction, or involve consideration of the question whether an injunction is required to protect the policies of the English forum. And the judge went wrong with respect to him by not setting out those principles. And then the extreme cases are dealt with, and I say this is one, if I need to, at 140C to E. Indeed, there may be extreme cases, for example, where the conduct of the foreign state exercising jurisdiction is such as to deprive it of the respect normally required by comity, where no such limit is required to the exercise of the jurisdiction to grant an anti-suit injunction. And then Lord Justice Mayall's his statements in SAS, in particular paragraph 111.
Sorry, paragraph
111 is the one, the two-way street is at 111. That's authorities 28,540 at 574. Two-way street. So just dealing with that extreme case argument, the principle is that if a state behaves in a way that this court considers to have gone too far, then it may be deprived of the respect it would otherwise receive. And our court is that the English, our case is that the English court does have a sufficient interest in this matter. The Russian state, on our alternative case, the extreme case, has behaved in such a way as to be deprived of the respect normally required by comity, such that, this is the importance of it, the court can feel comfortable in granting an ASI regardless of the comity principle, and here are the reasons. First of all, the Russian state enacted Article 248 specifically to deal with these sorts of cases. 248, your lordships will recall, is the specific provision referred to in all the authorities, such as Unicredit, under which the Russian courts have the Russian state has afforded its courts exclusive jurisdiction in, and I'm using broad language, sanctions related cases which might otherwise go to arbitration in other countries. And Article 248.2, dealt with in my skeleton and in, I think, the judgment, affords the Russian courts the power to grant their own anti-suit injunctions to restrain the arbitral or foreign proceedings that might otherwise have been brought. Now, that was a game changer and was brought in specifically to deal with this recent need to, through our eyes, to comply with, and in their eyes, not to comply with sanctions. It's not aimed only at this country, but it impacts all the time on these cases. It's the jurisdictional foundation, not the substantive foundation. The constitutional court cases are the substantive jurisdiction under which the claims are brought. But they arguably couldn't be brought without 248, and 248 is expressly pleaded in the pleadings as being the basis on which the cases can be brought forward in Russia in violation of the arbitration clauses. So, 1, Article 248, the Russian state. 2, the Russian courts, the Supreme Court and its rulings on joint and several liability, unfair contract for complying with sanctions. And 3, the Russian courts in our case or cases, firstly, granting interim anti-suit injunctions, which were in the evidence, in breach of the anti-suit injunctions that we obtained here. 2, the new anti-suit injunctions granted on a final basis, including one of the respondents, so they can't say nothing to do with me. And 3, the merits judgment given in the Perpetua case in flagrant breach of Lord Justice Lewison's order 2 days later. My third proposition was,
Very clear here, the court's not in breach.
no, the court is not in breach at all. The parties are in breach. The comity principle looks at whether or not your lordships will regard the Russian court and state as being as deserving the respect and regard that comity normally requires, or whether or not the framework that has been put in place is such that it allows learned friends clients and the other defendants to conduct themselves before the courts in an environment which has taken them beyond the pale in the eyes of the English court. So it's a complicated position because the anti-suit injunction is a personal order, but comity is the regard given by judges to foreign states and courts. Lord Justice Males has explained that to us, as have others. And so we say that the framework put in place by the state to allow the cases to be brought at all, 248, and the Constitutional Court's rulings, which give the development of Russian tort law with express regard to unfairness and tort liability for complying with sanctions, Western sanctions, as they're called, learned friends, pleadings abroad. And thirdly, what's happened in this case. So I've tried to break it out, but it is, the principles are clear. My third category I don't want to develop other than by, I've got time to develop other than by reference, and that is on the jurisdictional nexus, that's whether an arbitration has started. The references are easily picked up from Mr. Raphael's book at 4.81 to 2, authorities 34, 723, and examples are given in footnote 200, very helpfully. I was going to then develop points from the Emmett and Michael Wilson and partners case. Again, because of time, I can't, but there are principles from that case which stress the importance again of granting anti-suit injunctions to protect English-seated arbitration agreements or processes. Can I give the references? It's Emmett and Michael Wilson's at authorities 25.501 at 508, decision of St. Terence Etherton, Master of the Rolls, the Court of Appeal, paragraph 55. I'll just read the key section. The issue is whether the court in this jurisdiction, as the judicial guardian of the integrity of an arbitral process in London, pursuant to an arbitration agreement subject to the laws of England and Wales, ought to exercise its discretion in favour of an anti-suit injunction because some New South Wales proceedings are vexatious and oppressive in undermining that arbitration agreement and arbitration process. Learned Friend says at length that there is no case where an anti-suit has been granted in these sorts of circumstances, and with respect, we disagree. There are numerous cases. I'll mention some of them in a moment. The case law repeatedly makes clear that the English court will intervene to grant an anti-suit on the vexatious and oppressive basis to protect London arbitration. See, for example, the Asiana case, and I'll give the references to those when I come to them in a moment. See also my skeleton at 22.9. learned friend tries to distinguish Emmett by saying, this is his skeleton at 23.8, that the anti-suit granted in that case was aimed at preventing a party to the arbitration agreement relitigating claims, and we don't agree. The facts are complex, but the basic point from Emmett is that a different outflanking manoeuvre was being tried involving foreign litigation, but the response was the same. So whilst the facts are not identical, they do establish that the English court will intervene to prohibit a third-party joint and several liability claims, which do not themselves come within the arbitration agreement, from being brought abroad, where that would undermine or circumvent the arbitral process. Yes, learned friend in his skeleton talks about the underlying transactions being background, and that this is an overwhelmingly Russian set of relationships. Now, this is a new analysis, we say, because they say that the English court does not have a sufficient interest based on that analysis. And we say that there are several problems with that analysis. First of all, it begs the question of what law governs the claims brought in Russia. Because if the claims were brought in the LCIA arbitration, English conflicts of law rules would likely apply English law to the third-party claims, as we have argued in our skeleton, because those third-party claims are closely connected with the ISA agreements. And although, of course, the ISA agreements are between the contracting parties, we point again at the breadth of the governing law and jurisdiction clauses. It also acknowledges, but slightly because of the parentheses, skates over the point where the judge went wrong, and that is that one of the claimants in Russia, Perpekia, is in fact a Cypriot company. It's not a Russian company at all. They try and deal with that by saying it's a subsidiary of a Russian company. And the mere background point I've already dealt with and won't go into again. Now, what is the factual underpinning for sufficient interest in our submission in response? We say that the court is considering whether to grant, one, the application of a Cypriot party, my client, for an anti-suit to restrain tort claims in connection with English government contracts. Those tort claims would not exist if there were no contracts, which include London-seated LCIA arbitration clauses. That's the third point. Fourthly, where, if those tort claims were brought in LCIA arbitration, they would most likely be governed by English law, and where it is common ground that those claims, insofar as they concern me, are made on even though made on a joint and several liability basis, do fall within the arbitration agreement. So in accordance with the authorities, Airbus, Emmett, and Mr. Raphael's book, and the passage I gave before covers this as well, there is a strong, sufficient interest or connection in the interest.
You would add, I think, that these are claims which are founded on the proposition that compliance with English sanctions law is unlawful.
Yes, yes, I was literally just going to say that, but yes, thank you very much. Yes, I won't say that. On the public policies arguments, and so the English court's interest in promoting public policy or guarding it. As a reminder, there are three policies: arbitral process, protection of the court's orders, and the policies underpinning the sanctions legislation, at least of this country. One, arbitration policy. the learned friend says that the anti-suit would not protect any arbitral process between the respondents and my client because there is no extant or anticipated arbitration. Well, we've explained why that's wrong.
Yes.
They also say that the RRE claims would not interfere with any arbitration involving my client. And that's wrong for the same reasons that learned friend Skeleton, well, let me shorten this, wrong for these reasons. Firstly, the point I've just made that there will be interference because the claims against me should be brought in arbitration come what may. And if there's joint and several liability, if the Adorabella and Perpecia were to do what they ought, they should bring their joint and several liability claims against me, if they wish to, in arbitration in London. And then you're going to have, if there's no injunction, the possibility of two sets of proceedings looking at the same thing, possibly applying different systems of law because of different conflicts of law rules, and ultimately taking into account or not taking into account the defences available. Secondly, the purpose of the Russian claims is to outflank my clients, and that's a finding of the judge. He held, I think, paragraph 22, yes, page 65 of the bundle, second half of the sentence. I accept that the claims have been brought in Russia because the defendants are precluded from recovering their assets from Renaissance other than in LCIA arbitration proceedings against Renaissance in London, in which the defendants would have to prove their case that they were not properly to be regarded as subject to any relevant sanctions. So that's a holding of the judge on that point. Second policy, protection of the court orders. The anti-suit injunctions will be granted in order to protect orders previously being made by the court and Shell against Coral number 2, again, case which Lord Justice Males was involved is of relevance. Authorities, page, I think, 123, I'll check this. It's page 610, first column, subparagraph 2. Protection of policies underpinning sanctions. UK sanctions, learned friend says, are irrelevant. We say they're not irrelevant, at least at this stage, because of the holdings of the learned judge at paragraph 3, realistically arguable that the respondents are the subject of UK sanctions. There's a bit of dancing on a pinhead about the way we describe the sanctions that are being violated. The pleadings against us say capital W Western sanctions. And I don't really need to take the argument any further. There's a third element of the UK sanctions relevance, and that is tied to the policy of protecting the arbitral process. Because if by not going to arbitration when one ought, one is excluding the impact and relevance of the consideration of the impact and relevance of sanctions by way of defence, then that is another reason for having strong regard to the arbitral process. So that's all I wanted to say on my ground 1.1. 1.2, it's the heaviest ground in that area. 1.2 I can take very quickly. The judge didn't address my arguments on this issue. He just referred at paragraph 43 to my not having taken the points in the skeleton. And I don't think I need...
We understand that. If I may suggest, Mr. Lowenstein, given the limits on time on both sides, we've read your skeleton argument.
Yes.
We understand that you have criticisms to make of the procedure below,
Yes,
but it may be most helpful if you focus on substantive points.
yes, thank you. There are a lot of points taken against me on the procedural matters down below. I just put down the marker that the references to cases like Pigloska and all that just don't help. I'm not going to go through those one by one. Let me come to ground 2 very briefly then, because of time. If my client, which we say it wasn't, was required to identify as a matter of law an alternative forum to satisfy an inchoate threshold forum issue, or for any other reason, then firstly, the judge just didn't address the arguments I did put to him by the reference to the skeleton, and secondly, there was an alternative forum. And we've set out the reasons for that in the skeleton, which I don't need to develop. They are between paragraphs 34 and 40. In response to my learned friend, paragraphs 31 to 33, it suggested that this is a new point that I'm taking. Lord Justice Lewison expressly found that the point had in fact been taken below, and gave me permission to run it, Core Bundle 10, page 151, by reference to paragraphs 36 to 37 of our skeleton below. The reason that this is relevant, this alternative forum point, is that learned friend is saying that were I to be right, his clients would be forced into arbitration, forcing, and that's wrong, because the question whether there is, it doesn't matter for these purposes whether these respondents have or have not consented to that forum for their dispute with the RREs. What they have done is consented to the LCIA for their disputes with me, and were they to sue there, the RREs could be joined. That's the only relevant question there. We're only asking whether there is a forum. So that's why we say this is an alternative forum case. It's as simple as that.
Well, we know that the RREs would consent.
There are letters.
No,
Sorry, I'm so sorry.
because the clause says that they have to give their consent following the commencement date,
Yes.
which is the date of the commencement of arbitration.
Yes.
That's not happened yet.
Mm.
So they would need to say something in the future. How do we know that they would do so in circumstances where you've sold them and no longer control them?
Yes. So consent is not a fixed single moment. Those letters are submitted and have not been withdrawn, and yet there is a line of evidence, Luchanovsky 5, paragraph 13, supplemental bundle 13392, which says, confirms that...
Sorry, paragraph?
Luchanovsky 5, paragraph 13.
Thank you.
Which confirmed that at no point have the RREs resiled from or contradicted this position. So like, I mean, very bad analogy, a continuing offer. Their consent has been given. The best that the respondents can say is they may withdraw their consent. Well, they haven't. And so that consent has been...
Yet. Nobody's tried to join them in an arbitration.
But they have said that they would join if they would submit...
That's when you owned them. You don't own them anymore, you don't control them.
Well, I do control one of them, and they haven't withdrawn their consent. So as far as the one goes, and if your lordship's point needs direct answering, then one is still in the same group. Two have gone out, but when they went out, did not withdraw their letters. And so there is...
The owners may not know about the letters.
Well, I can't speculate.
No, neither can we.
No, you can't. But so the position on the ground is that there are consent letters that have been given. It's quite an important thing, and again, speculating, anybody doing diligence on this sort of sale would see recent correspondence, particularly given that these disputes must have been important at the time of the sale. The sale was a few days after the hearing before is on Judge Pelling, and so it can't have been overlooked. Again, speculation, but the consent is there, and there is no suggestion that they wouldn't. So I don't want to overlabour the point. The best evidence is that consent has been given, and at least one of them on the evidence that's before you is still connected. Even if they didn't consent when it came to it, that's not fatal to my case. But the judge thought it was. And it's not fatal because if it then becomes a single forum case and not an alternative forum case, then the court has to decide whether or not either of the limbs of Airbus is still met, notwithstanding the non-availability of the alternative.
That's ground one.
That's ground one,
Yeah,
and I've been
yeah,
there. So
yeah.
just to make it clear.
Just in terms of what you could do, you could start an arbitration
Good.
against the respondents in which you seek a declaration of non-liability.
Yes.
It seems to me you could also seek a declaration of non-liability jointly and severally with the RREs,
Yes.
including their non-liability.
Yes.
So that you could have an arbitration at which that is at issue with these respondents.
Yes.
So that issue would be live in an arbitration
It would.
without involving the RREs.
Yes.
And if they wished, and then it would certainly be an available forum for them as against the RREs if they wish to join them.
Yes.
If the RREs consented.
Agreed. Yes. And it hasn't been done yet, obviously, but it is possible.
You could give an undertaking to do that.
I could, and I'll take instructions about that.
Mhm.
Unless your lordships want any more, I'm conscious of allowing my learner junior some bandwidth, and so I'm going to move to ground 3, which I can take.
You really covered this, haven't you?
I think we have. I'm just going to check if there's anything I haven't said. Yeah, it's the 248 point. So we say, first of all, he didn't look at our arguments, but 3.2 is the mistake about the way that the one point he did deal with was dealt with, and that is, it seems from reading paragraph 44 of the judgment that he and where he referred in terms to the last point, that he got the wrong end of the stick as to what we were saying about 248, and that is, I think he thought that we were saying that 248 was a complaint about a substantial ground of claim against us. It wasn't. It's the jurisdictional, to use our language, gateway through which the claim then proceeds. And then the complaints I was making were the collateral attack and the orchestrated attempt. The orchestrated attempt is the same arguments as I put forward in relation to the extreme case. The orchestrated attempt is all the building blocks that have to be put in place and were put in place in Russia. 248 for jurisdiction, Supreme Court for the applicable tort law, and then the conduct in the courts to allow these claims to proceed. And without all of those things, yes, it couldn't. That's the orchestrated attempt that we were referring to in the shorthand in our skeleton. And the collateral attack is well-known English language in relation to not only contracts, but the contracts in arbitration agreements. And so the use of the language, the Russian legislation was the first step. And the judge concluded that my arguments were wrong, and with respect, he looked and he made a mistake and he looked at the form, not the substance. I've set out the law in this area at 22.6 to 22.8 of the skeleton. And just trying to see whether I need to repeat any of the arguments other than rely on my skeleton. The first element is the mistakes about 248. That's 44.3 little 1 of my skeleton. And 46. And thereafter. No, I don't think. And then yes, I just say that the judge, no, that's all there as well. And then 44.3.2, which is the nature of the claims I've already dealt with elsewhere. It's not all Russian. It is far from being all Russian. The context is very important in the exercise of the ASI discretion, and that's the cases tell us one has to look at the broader context, not just the narrow formulistic approach. And the context that the court is grappling with is the workaround being used, the ignoring of some of the court's orders, the flouting of the injunctions, and the need, for example, by Mr. Justice Foxton to be troubled twice in vacation to spell out orders, the need to go back to Mr. Justice Butcher in September to have him spell out an order because of lip service being paid, and the most recent breach, the final anti-suit injunctions obtained against us. And we would say, with an eye on this hearing, Apekia have obtained an anti-suit injunction, which on one reading should have perhaps, I don't know because I'm not a Russian lawyer, I can't interpret their injunction, but an anti-suit injunction requiring my clients not to proceed with this action, obtained on Tuesday. Final. I don't need to develop the skeleton on that. I've got one or two points to make in response. Yes. Yes, we put at the forefront of our arguments the Asiana case. Can I just give the references to it? Lord Justice Lewison referred to paragraph 77 in his judgment, which is important. In Asiana, the passages we rely on, paragraph 74, where he talks about evading, the Chief Justice talks about procedural manoeuvres designed to evade an exclusive jurisdiction clause. Now, I know that in this case it's an arbitration clause, but it makes no odds. It's a choice of forum clause that should be given, to which a regard should be given. And the law in this country is being brought into line only last year. In a case in the Privy Council in which I appeared, the Privy Council started to elide the rules in relation to exclusive jurisdiction clauses and arbitration agreements in particular contexts, saying that the tests to look at, that's the Cyan participation case, it's not in the bundle, that the approach should be the same. The Donohoe and Armco approach is correct, and there shouldn't be a difference. And then one knows the differences in these tests are being elided. But here it said, well, it's an arbitration clause and there's some great difference. There isn't. And the categories of what counts as vexation or oppression are not closed. In Asiana, there is an analysis of a Hong Kong case called Giorgio Armani, which is another example of just this sort of injunction being granted. That's paragraph 75. We can provide copies of Giorgio Armani. Learned friends didn't want it in bundle. I'm happy to give it if you want, but it's dealt with quite well at 75, 76 in the Asiana case. And in Asiana 77,
Is Giorgio Armani a first instance or appeal?
I think it's an
case?
appeal case in Hong Kong. It's an appeal case in Hong Kong. Yes, it is. It is. Yes.
Right.
I will provide copies of it, but it's set out at great length in the Singapore style in the Asiana case. I think probably one of the great advantages of having judicial assistants who can do that work. But in Asiana, paragraph 77, Chief Justice, this is the paragraph to which Lord Justice Lewison referred, said that an ASI may also be granted where the court finds that the foreign action has been brought against the non-party for ulterior reasons, namely to bypass or avoid the constraints of the exclusive forum clause. In the latter category, amongst the key considerations is whether in pursuing the foreign proceedings, the ASI respondent is, in truth, seeking to evade its obligations under the exclusive forum clause, or is in some way acting in bad faith. In such a situation, if the court grants the ASI, it will have been satisfied that the action against the non-party was not being pursued for a legitimate purpose. So we say that that is useful here.
Should we insert at the beginning of paragraph 77 some words to clarify? Does he really mean, in our judgment, where an ASI is sought to restrain an action against a party that is a non-party? Because that's the sense of it. There's no. I mean, you are seeking action against somebody who is a party. So
my case is stronger than Asiana. None of the cases are on all fours, but many of them are as near as you can get. Learned friends incorrectly say that an ASI has never been granted on facts such as the present. The distinctions they give are so narrow that it's very difficult to understand some of them. But we've got Asiana, we've got Giorgio Armani, and we've got the BNP Paribas case of Justice Blair proved in the Court of Appeal. It's very slightly different because there the foreign proceedings were brought by a non-party against a party to the arbitration agreement. It's the other way round, but the same principle applies. You stand back and ask what the substance is, not the form. Learned friends' responses are all, oh, this one's the other way around, so it can't be relevant. Doesn't matter. Yes. And I accept that there are small differences between the cases. Parties are the other way round. Tripartite relationship in every case. But the question is, who is trying to do what where? Just as they were in those cases that I've said. I think I have used the time available to me. I'm going to reserve on the further points that my learned friend has taken. Those are submission to the Russian jurisdiction, to which in a line there is a dispute about it, which can't be resolved, but it's certainly strongly arguable on the evidence that I have that there hasn't been submission by the RREs.
Yeah, and we've read the evidence from each side about that.
Thank you. And the other one is no legitimate interest, and I've already given a short submission on that. So I just reserve that and on any other points.
Yes. It's very helpful, thank you. Yes, Mr. Gilmore.
Grateful. My lords, I will address you on ground 4. This is addressed in our skeleton argument in section D, paragraphs 57 to 69.
Yes.
We submit the judge misdirected himself on the applicable principles and misconstrued the relevant arbitration agreements. Subject to the court, I propose making submissions in 2 parts. I will begin with the authorities and principles of contractual construction. And second, I will address the court on the terms of the ISA itself and points made in my learned friend's skeleton argument.
That's fine in principle, but bear in mind that you've got 12 minutes.
I do.
And
I
I think we're familiar with the principles of construction.
I'll try and take the authorities very quickly then. 3 basic propositions of law. First, forum agreements are to be construed broadly, generously, and purposively. Second, arbitration agreements are generally understood to contain a positive promise to bring disputes in their scope in arbitration, and a negative promise not to bring disputes falling within their scope outside of arbitration. And I think that analysis is a helpful way of thinking about some of the points that arise on this case that I'll come to. Third, my lord, it is well established that parties may contractually promise not to sue a third party to that contract. So my lords, just stopping there, I want to be clear on what our case entails. Our case is that the arbitration agreements in this case included a negative promise not to bring outside of LCIA arbitration joint tort claims arising from the contract, where the claim alleges joint liability against a party and a non-party. And the reason why I raise that is because there was some confusion in the judgment below about what our case does and does not involve. Our case on construction and the Clear Lake line of authority does not require, as the judge appears to have thought, that claims against third parties be arbitrated. It does not involve forcing the respondents to do anything. It does not require that any rights be conferred on third parties. It does not conflict with privity of contract as a result. It does not raise issues of comity, as the judge appears to have considered. Turning to the Donoghue line of authority, I won't take you to the authorities, but there are a few propositions that I think it is worth emphasising. The key reason in Donoghue as to why joint tort claims against parties and non-parties will tend to be covered by a forum clause is that if that were not the case, that would substantially reduce the protection afforded by the clause. And the reason for that is that a contractual counterparty can circumvent a jurisdiction clause by suing a third party as a joint tortfeasor and then leaving the third party to sue the contracting party for a contribution. Now that differentiates joint and several liability tort claims from other forms of third party claim. The second point I want to make is about the specific nature of the joint tort claim advanced in this case, because it might be said, and indeed Asiana takes a similar kind of analysis, that Lord Scott's approach is over-inclusive in the sense that there are a spectrum of potential joint tort claims giving rise to contribution claims, and not all will necessarily fall within a forum clause. My lords, we don't think it would be an over-inclusive. Ultimately, it all turns on the particular case, and we would respectfully submit that those claims which, 1, otherwise come within the scope of the arbitration agreement, 2, raise the same or substantially the same factual and legal allegations, and 3, expressly plead joint and several liability against both are those which are most likely to have been intended to be covered by a forum clause. In this case, it is not in dispute that the RRE claims, which plead that Rensec and the RREs are, and I quote, a single person, satisfy all 3 of those criteria. The third point I want to make very briefly is about forum fragmentation. This is the reason Mr. Burrows QC, as he then was in Clear Lake, gives for why joint tort claims will tend to be covered by arbitration agreements. The fourth submission we want to make is again about Clear Lake, and in particular the 5 factors Mr. Burrows identifies. Now, that's at paragraph 37, as to why the facts of that particular case might justify a departure from what he calls the starting point. Now, we've analysed those 5 factors in paragraph 66 of our skeleton, but there's one point that I wanted to emphasise. What Mr. Burrows says is that if the joint tort claim is pleaded against both a party and a non-party, you would expect the claim against both to be prevented by the arbitration agreement. And he goes on to say it shouldn't matter if the claim is made only against the non-party for these purposes. So our case we submit is on all fours with that analysis. The Perpecia claim is pleaded against both parties. The Adorabella claim is pleaded only against the RREs, but we say it shouldn't make any difference. And I would emphasise that Mr. Burrows in that case, he clearly thought that where the joint tort claim is pleaded against both, it does come within the arbitration agreement. Fifth, just very briefly, Cavendish. This was not a joint tort case. The analysis there is pitched at a high level of generality. Mr. Rabinovitz was talking about third-party claims generally, rather than joint and several tort claims specifically. And while he did refer to Donoghue, he did not specifically address the concerns raised by Lord Scott in that case about joint tort claims. So for these reasons, we submit that the judge was wrong to find there is a meaningful tension between Cavendish and Donoghue. That is especially the case because, as Mr. Burrows found, ultimately it is a question of construction of the particular terms of the forum clause. So, my lord, having made those submissions, the last point I want to make is just about the so-called starting point. The judge's approach, we respectfully submit, entirely ignores what Mr. Burrows, citing Donoghue, said about the reasons why joint tort claims will usually be covered. Mr. Burrows did not harden the starting position into any kind of rebuttable presumption, as appears to be treated by my learned friend and the judge below. Nor did he think that specific terms in the contract expressly addressing third parties were required for a forum clause to cover claims against third parties. The correct approach is that set out in Clearlake at paragraph 24. And while generally third-party claims are not covered by a forum clause, it is also true that generally one would expect rational commercial parties to have intended that joint tort claims against a non-party and a party will be prohibited by a forum clause. Now, it doesn't ultimately matter for the purpose of the appeal, but in our submission, in the light of this analysis, the language of starting point may be inapt or require modification when you're dealing with joint tort claims. So, my lord, turning to the respondents' 5 points in their skeleton, which essentially rehearse what the judge found in the court below, I would first note that they don't address the 5 factors in Clearlake at all. So they don't address the nature of the claim, the fact it's a joint and several tort claim. They only address the terms of the contract itself. Their first and second points, which are really their main points, can be taken together. The first is that the ICEs include a requirement that for a dispute to be referred to arbitration, the parties must have first sought to resolve it in negotiation. And the second is that ICEs provide any arbitration award will be binding on the parties. And they suggest that these provisions mean that the clause only covered disputes between the parties. However, we say that analysis cannot be right for 2 reasons. The first of those is that these parts of the clause are in fact consistent with our construction. They concern the positive promise of the parties as to which disputes will be heard in arbitration, namely disputes between the parties. They say nothing about the parties' distinct negative promise as to which disputes they will not bring outside of arbitration. So in that regard, they're no different to an ordinary arbitration agreement, which does not refer to negotiations between the parties, where the Clearlake construction of an arbitration agreement arises, if I can call it that, that involves a positive promise to bring certain disputes in arbitration, but those will only be those involving the parties to the arbitration agreement. That doesn't say anything about the separate negative promise. And the second point, my lords, I'm afraid I'm not going to have time, I don't think, to take you to the ISA and its terms, so I will make this point and just give you the references.
That's fine.
The significance and meaning they derive from these terms is contradicted by the other terms of the contract we would submit. In particular, pursuant to clause 24 of the contract, the customer, that is Perpecia or Adorabella, agrees to indemnify Rensec, but also a number of defined third parties namely the associates, their successors and assigns. The same point can be made about clause 26, set off, and clause 40, assignment, each of which grant rights to third parties, which presumably would be enforceable via arbitration. Clause 41, which concerns third party rights, confirms that indemnified parties and associates, as defined, have rights under the agreement. Now, my lords, the reason this undermines the respondent's case we submit is because these third party rights must be enforceable by those parties pursuant to the arbitration agreement. For this reason, the reference to a requirement for the parties to negotiate in the clause cannot be determinative of its scope as it relates to third parties. There are clearly third parties which would be entitled to arbitrate pursuant to the clause, given the other terms of the agreement. My lords, very quickly, if you'll permit, just addressing the third, fourth and fifth points in their skeleton. The same analysis applies to the third and fourth points they make, really. Those concern waiver of immunity in relation to service of process. Again, this concerns the procedural aspects of those claims which the parties have positively agreed to arbitrate. It says nothing about their distinct negative promise about those claims which they have promised not to bring outside of arbitration. The fifth and final point in their skeleton concerns the reference to the Rights of Third Parties Act. And again, we respectfully submit this is wrong as a matter of principle. It only works if the relevant question of construction is whether the parties intended to confer rights on the RREs under clause 43.2. But that is not the right question and is not RENSEC's case. The relevant question is what are RENSEC's rights under the agreement? I've managed to get through that in 10 minutes. So
that is admirable. Thank you both very much. And Mr. De Cruz, we look forward to hearing you at 2 o'clock.
What, why is it